So again, welcome everyone. This is Student Discipline and IEPs, What You Need to Know, presented via webinar on May 2nd, 2023 by Attorney Jennifer Grobe with McAndrews, Mehalick, Connolly, Hulse, and Ryan. The Arc of Lehigh and Northampton Counties disclaimer. The Arc of Lehigh and Northampton Counties Advocacy Department does not employ lawyers nor provide legal advice. This training or any other provided by the Arc's Advocacy Department does not constitute or imply the endorsement, recommendation, or favoring of the provided party or any employees or contractors acting on its behalf. This webinar is being provided for educational and informative purposes only. All right. So now it is my pleasure to introduce Miss Jennifer Grobe. Ms. Grobe earned her Juris Doctorate from George Washington University Law School in Washington, D.C. Additionally, Ms. Grobe interned with the U.S. Department of Justice, Civil Rights Division, Disability Rights Section, the U.S. Department of Education Office for Civil Rights, Philadelphia office, and the Public Interest Law Center of Philadelphia. The practice areas she practices in are within civil rights, special education, and civil litigation. So thank you for joining us this evening, Jennifer. The Zoom is yours.
Good evening, everyone, and I'm so happy to be joining you tonight and glad that all of you were able to join us as well. It's great to see that we have such a range of experience in this topic and hope to be able to make the information relevant to all of you. Please feel free to add your questions into the chat box or to the Q&A as we're going through the presentation of information or through the PowerPoint. I'll try to incorporate the questions as they relate to the material, but we will also have time for questions at the end. All right, so as you're aware, the topic we're going to be talking about tonight is student discipline, particularly pertaining to students with IEPs or students with disabilities, and what you need to know about disciplinary actions and the responses and actions that are available to you as a parent or as a professional when a student is being subjected to disciplinary action. So before we get into the specific regulations as they apply to students with disabilities, it's important to know generally what governs the rules of discipline and the disciplinary authority of schools is under the state's code. So we're going to be talking about Pennsylvania because we are because the Arcs of Lehigh is in Pennsylvania. We are all, I'm assuming, practitioners or parents that are in Pennsylvania, but other states would have comparable codes and regulations as well. So the Pennsylvania Code has a chapter that governs all disciplinary actions for all Pennsylvania students. And then the governing board for each local education agency would be responsible for defining and publishing the specific disciplinary types of offenses that would lead to disciplinary exclusion and the grievance procedures and processes that would accompany that. For students with disabilities, there is an additional chapter of the Pennsylvania Code that governs, and that's chapter 14 of the Pennsylvania Code, as well as the Individuals with Disabilities Education Act, the IDEA, which is the federal law governing the special education rights and entitlements of students with disabilities. So some terminology that you'll want to keep in mind as we're going through this conversation tonight is that there are several different types of disciplinary actions that a school may take. The first is suspension that we're going to talk about. And a suspension is defined under the Pennsylvania Code as exclusion from school for 1 to 10 consecutive days. If a student is being suspended for 1 to 3 consecutive days, the school is supposed to have an informal meeting to review what is being subject to discipline and kind of how the response is going to be after that. It does not have to be an informal hearing or a formal hearing if it's 1 to 3 days. If a student is being suspended for 4 to 10 days consecutively, parents and students have the right to an informal hearing, which includes written notification of the reason of suspension, sufficient advance notice of time and place of hearing, the ability to question witnesses, and it has to be held within the first 5 days of suspension. And these are, again, the rules that govern for all students, regardless of whether or not they have a disability. There are no time limits for in-school suspensions, but in-school suspensions do not entail anything that means exclusion from school. So in-school suspension can mean exclusion from class, but it's not exclusion from school. So expulsion is exclusion from school for more than 10 consecutive school days or for 15 cumulative school days over the total school year. And if a student is being excluded for more than 10 days consecutive or more than 15 days cumulatively, there has to be a formal hearing held by the school district. And there are due process rights that attach to that formal hearing, which are going to be more robust than in that informal hearing, which includes receiving prior written notice of the disciplinary offense that's being subjected to expulsion, or to a decision whether or not to expel. The family has a right to present counsel, to present witnesses and cross-examine and testify. The hearing must be recorded and a transcript created that is available to the family after the proceeding is adjourned. There must be a written adjudication containing findings and reasons after that formal hearing. And then the family has 30 days to appeal to the local court of common pleas if they contest that expulsion decision. And for expelled students, if a student is under 17, they must attend school. And if they're expelled from their local public school, the parents can look at another public school, charter school, private school, homeschool. But if they can't arrange any of these, they have to state in writing to the school district that were unable to identify or locate an alternative school placement. And then the district becomes responsible for making provision for the student's education. So and it's for students without disabilities. The parents have the responsibility to try to identify alternative educational placement. If they can't, though, the onus comes back onto the district. Now we're going to talk about how the Individuals with Disabilities Education Act, the IDEA, implicates disciplinary procedures for students with disabilities. There are additional disciplinary procedures and protections when a child has a disability. And so school districts aren't prevented from disciplining students with disabilities, but there are limits and requirements when there are disciplinary measures being imposed. Primarily, the IDEA is concerned about disciplinary exclusions that amount to a change in this child's placement. And the reason that the IDEA is concerned about that is because placement decisions for a student with disability are intended to be decided by the IEP team, which includes a special educator, regular educator, parent, local education agent, and all of the relevant personnel working with student. Changes in placement are not a unilateral decision by a school official for a student with a disability. So the IDEA limits a disciplinary exclusion that amounts to a change in placement, particularly when the behavior that gave rise to the violation of the school's code of student conduct is determined to be a manifestation of the child's disability. So if the behavior that violated the code of conduct is determined to be a manifestation of the child's disability, then there are limits to the disciplinary exclusion that the school can implement. And we're going to go much more in depth into that, but that is just kind of a general statement of what the IDEA protects for students with disabilities. So when we say students with disabilities are protected under these disciplinary protections. Of course, we're talking about IDEA students who are already deemed eligible under IDEA, who already have an IEP in place. It also includes, however, students who have a 504 plan in place. The same protections support them. And additionally, students who are thought to be eligible are also protected by these disciplinary protections. And students are thought to be eligible if the school has reason to believe or has demonstrated they have reason to believe the student is a student with special education needs or a disability in need of an IEP or 504 plan. So the protections are expansive beyond just the students who are already qualifying for an IEP. So what is a disciplinary change in placement? So a disciplinary change placement occurs in 5 particular scenarios. A student with a disability's placement is changed if they are removed for more than 10 consecutive school days, if they are removed for more than 15 cumulative school days in a school year, if school days 11 to 15, above that 1 to 10, constitute a pattern of exclusion, if a student with an intellectual disability is excluded for even 1 day, that is a disciplinary change of placement. And if a student is being excluded under the 45-day exception, which we will talk about in a little bit, if they're being removed to an interim alternative education setting, IEPs, for violations involving drugs, weapons, or serious bodily injury, that is also a change of placement. And as we said, changes in placement are an IEP team decision. They're not a unilateral decision by school personnel. So, looking at this, if a student is being suspended for 1 to 3 days or under 10 days generally, that is not a change in placement. These are the very specific times when a disciplinary change in placement is going to trigger the obligations under IDEA to conduct that manifestation determination. So what we're going to talk about a little bit, and what the ARC was interested in, was talking about patterns of removal, which is those informal removals. So Jessica was talking about before, when the parents are getting repeated calls home saying, you need to come pick up your kid because they're having behavioral issues and they can't stay here. And it's not officially, it's not an official disciplinary measure. There's not a paperwork saying he's being suspended, but he's being removed from school. If that is repeatedly happening, or if there is a pattern that's developing, which we'll talk about in what scenarios there might be a pattern, then even if they're not calling it a suspension, even if they're not formally removing the student, it could constitute days that count towards the limit of days of exclusion that ultimately result in a change in placement. So generally, as it says here, a pattern of removal are actions that result in the denial of access to and significant changes to the child's educational placement, which can be considered part of the 10 days of suspension or 10 to 15 days of suspension, and can constitute an improper change in placements. And there's many examples of how schools might be engaging in a pattern of removal. So for example, as we talked about, when an administrator calls and says, come pick them up, they're misbehaving. If the administrator is saying they're having difficulties, let's move them to half days, or let's keep them home on Wednesdays, unilaterally, that's not an IEP team decision. That could be a pattern of removal. If there are certain classes or areas within their regular program that they're being prohibited from attending, like elective courses, that may constitute a pattern of removal. So the regulations of that were put out by the Office of Civil Rights for the Department of Education describes a pattern of removal as a series of formal and informal removals that constitute a pattern if they total more than 10 school days in a year, and the child's behavior is substantially similar to the child's behavior in previous incidents that resulted in the series of removals. And consideration to additional factors such as the length of each removal, the total amount of time the student has been removed, and the proximity of the removals to one another. So let's say a student is having emotional regulation issues, having outbursts, throwing things in the classroom when they get upset. If you're repeatedly getting calls or they're saying, they can't be in class because they are throwing things in the room, you have to come pick them up because they're not behaving themselves. And it's day after day after day in a close period of time, or repeatedly, same behavior, that would probably constitute a pattern of removal that would ultimately reflect a change in educational placement. So informal removal in itself is not defined in the IDEA, but it's mentioned in those 2022 federal regulations that I mentioned. And informal removal is it overlaps with this idea of pattern of behavior or pattern of removal. It means an action that's taken by the school personnel in response to a child's behavior that excludes the child for part or all of the school day, or even an indefinite period of time. So as we discussed, that could be reducing the school day outside of the IEP team and placement process in response to the child's behavior. And frequent use of short-term disciplinary removals or informal removals of children with disabilities may indicate, and probably do indicate, that the child's IEP does not appropriately address their behavioral needs, which might ultimately result in a denial of a free, appropriate public education. But there are several factors that school districts are instructed to consider when they are making decisions that involve short-term removals. The school district, and this is as part of this 2022 regulations. School districts are instructed to consider the circumstances that led to the child's removal, whether the child was being provided services in accordance with their IEP, so that whether their services were being implemented with fidelity. They have to consider whether the behavior can be addressed through minor changes to the classroom or program practices. And they have to consider whether the IEP team should be reconvened to address possible changes to the IEP. And, if we're seeing multiple days, multiple exclusions or disciplinary measures taken based on the same behavior, odds are the IEP team should be convening to discuss what's going on here and to come up with a plan that everyone will be implementing together. And we'll talk a little bit more later about how we develop plans for behavior intervention. So in-school suspensions are not defined by the IDEA, but they're mentioned in those 2022 regs again. So in-school suspensions are when a child is temporarily removed from their regular classrooms for disciplinary purposes, but remain under the direct supervision of school personnel. And in-school suspensions can be considered a part of the days of suspension that would amount to a change in placement, unless there are certain precautions taken in place. I'm going to get to that on the next slide instead of reading through that. But the important thing to know about that is, even if you're not being called to come pick your student up, if your student is being sent to a quiet room, calming room, spending most of their day outside of the environment that they're supposed to be in, supposed to be receiving their services, but they're still in direct supervision of school personnel, and these removals are happening because of their behavior, this could be considered days of suspension, depending on how long they're being removed and the pattern that's associated. So a school's actions would not be considered a disciplinary removal if the child's afforded the opportunity to continue to appropriately participate in the general curriculum, if the child continues to receive the services specified in their IEP, and they continue to participate with non-disabled children to the extent they would have in their current placement. So not every move of the student out of the classroom is going to be considered a disciplinary removal if these other protections are afforded. And just something else to keep in mind is transportation, because I know that transportation can often be an issue. Parents can be told, they're not behaving on the bus, you need to transport them yourself. Transportation is a related service in IEPs that school districts might be required to provide in order for the student to receive a free appropriate public education. A student might require particular transportation in order to access their education during the day, to start on a good footing, get into the room ready to learn. So often you will see transportation in IEPs. And therefore, if a school is refusing to allow a student to access that transportation, it is also can be treated as a suspension, as a disciplinary exclusion from their transportation, and should be addressed and viewed same way as we're viewing all these other changes in placements. So something that we wanted to discuss is what can we do when we're having these informal disciplinary measures, because the statute says exactly what we can do when there's a certain amount of days of formal suspension or of actually pursuing an expulsion. But when you're just getting these repeated calls or these changes without it being documented, without it going through the normal procedures, what as a parent, what as a professional can you do? So my advice always is document it, write it, put it in writing and email it and communicate it. Whenever there is an issue, you got to put it in an email and communicate it. Yeah, and that can just be, it's my understanding or that so-and-so was sent home today or was not allowed to attend majority of class this day due to their behavior. This is a disciplinary exclusion from their program, and it should be considered a suspension or counted as a suspension when looking at whether the school is changing their placement, something like that. Just something that's notifying, documenting they were excluded today, and how they were excluded and why. I recommend that you independently track all of these disciplinary exclusions, write down the date, what happened, and what the disciplinary measure was. Confirm that these are being documented in their IEP and perhaps their disciplinary records. The records of their suspensions and days of suspension like that shouldn't be following the student to for example, on college applications or in that context, but it should be part of their current school record for determining how their current progress and how they're doing. So you would want any informal or formal exclusion to be included in that IEP or disciplinary record. You can also request an IEP meeting. Even if it happens once, you can request the IEP meeting. You don't have to wait until it becomes a pattern and say, this happened in school today, I'm concerned, I want to convene an IEP meeting. And you can also request a reevaluation or a functional behavior assessment to address the concerns that have come up. Look at some of the questions you have right now. You will get a copy of the slides after the webinar. These rules apply to children of all ages in a public education program, which would be either a public school or a charter school. These rules do not apply to private schools. They have their own regulations and are not subject to IDEA. Exclusion from events like senior prom and graduation would not be factored in as these disciplinary exclusions that are resulting in a change of placement. That is separate from the placement, those placement decisions, which is the main concern about disciplining students with disabilities. One question is there any difference between expulsion or suspension legally and in practice by schools? So in Pennsylvania, a suspension is less than 10 consecutive days of being excluded from school. And an expulsion is being excluded for more than 10 days or consecutively or more than 15 days cumulatively. And the 1 to 10 days of suspension or less than 15 days of suspension cumulatively typically won't give rise to the IDEA protections. We're going to be looking at when the student is being expelled or there's a pattern of exclusion that the student is encountering. A good question also that just came up: does this apply to private schools where the student is placed and still has an IEP? Yes. If a student is placed by a NORAP or they're an IEP in a private school, the school district is still their local education agency responsible for ensuring that they're receiving a free, appropriate public education. So it's if a student is unilaterally placed in a private school by the family, then and the school district is no longer involved with the student's education, then these disciplinary protections are not in place. And there's not this form of relief available or mandatory for this private school to engage in. But if the private school is a placement via NORAP, then yes, these protections are in place. However, the private school may have a greater ability to state, we do not feel we're an appropriate provider for this child, and we therefore we don't think they should be attending here anymore. And that is going to be given deference by school district, and if you appeal it, by a hearing officer. If the private school that the school district has placed them in says we're not an appropriate placement here, then it'd be a tough argument to say, no, you have a responsibility to keep doing this, even though you don't think you can. Another question: what if a student is constantly removed from class but never sent home? If a school calls over and over to let them know, parents know about the behavior, they're spending days in the school psychologist office, the sensory room. So that is what we're looking at, those informal removals or in-school suspensions. And an in-school suspension, as we discussed, could be considered a disciplinary exclusion if they are being removed from their educational environment and they're not being afforded the opportunity to continue to participate in their general curriculum. They're not receiving the services specified in their IEP, and they're not participating with their non-disabled peers to the extent they would have in their current placement. So a student who is every day going to a sensory room, going to guidance counselor's office, and not being taught in their educational environment that's prescribed in their IEP, those days could constitute in-school suspensions that go towards counting the days that would be the days of disciplinary exclusion that would amount to a change in placement. Okay. Another question: what if the school calls it for pickup at the end of the day because they're afraid to put them on the bus because there's no para, et cetera, on the bus? Lack of staffing, and I know this is a huge issue that a lot of schools are facing right now, and it's tough. It's really tough, but a lack of staffing isn't an excuse not to implement a child's IEP if that's what they're entitled to. So if a student is being excluded from transportation because of their behavior, and there's a pattern of that that's developing, that may amount to a change in placement. If it's 1 to 3 days of being excluded, that's not necessarily going to amount to the change in placement. We're really looking at if there's a pattern developing, if this has happened more than 15 days in the school year. And this is, thank you for this clarification. OSEP and OCR's guidance, 2022 guidance is guidance, not regulations. That's absolutely correct. Thank you for pointing that out. It is guidance that is suggested for schools to follow, but it is not regulations under the law, which they must comply with. However, that federal guidance carries a lot of weight with hearing officers and with the state. I'm going to go through a little bit more and then maybe go back to some questions. Okay, so now we're going to talk about manifestation determinations. And this is a process that's triggered when a student with disabilities disciplinary exclusion amounts to a change in placement. And as we discussed, that's those 5 scenarios. It's 10 consecutive days of exclusion, 15 cumulative pattern of exclusion for similar behavior for based on circumstance, any days of disciplinary exclusion for a student with an ID, or a removal to an interim alternative education setting based on certain offenses. So when there's a disciplinary change in placement, within 10 days, the school has to hold a manifestation determination meeting where relevant personnel, including the LEA, who is the local education agency representative, the parent, and relevant members of the team meet to determine whether the behavior that's being subjected to discipline was a manifestation of that student's disability. Something to keep in mind that IEP teams are not prohibited from conducting a manifestation determination review during other situations when a child's behavior is inconsistent with the school's code of conduct, but these are the specific, when there's a change in placement, when exclusion amounts to a change in placement, a manifestation determination review is required. So the purpose of this manifestation determination meeting is to determine whether the behavior of the student for which the school district seeks to suspend or expel is a manifestation of that student's disability. And like I said, it must occur within 10 days of the decision to change that child's placement. And the members must include a representative of the school district who has decision-making authority, an educational decision maker, which is typically a parent or guardian, and relevant IEP team members. So there are usually school districts are going to have a form they go through for the manifestation determination review, where they look at what is the incident, they're different, fill in the blanks they fill out. PTAN usually, who I hope you're all familiar with PTAN, the Pennsylvania Technical Teaching and Assistance Network. I think I got that acronym right. Has guidance on or recommended documents on how school districts should be structuring their manifestation determination reviews. But essentially, manifestation determinations are the team coming together to answer 2 questions. They're asking, was the conduct in question caused by or had a direct and substantial relationship to the child's disability? Or was the conduct in question a direct result of the LEA's failure to implement a proper IEP? So those are the 2 questions that the team's looking at to see if the conduct that's being disciplined was a manifestation of this individual student's disability. So if the answer is no to both, that, the conduct that's being disciplined isn't related to their disability, and no, they have an appropriate IEP in place, and this wasn't related to that IEP not being implemented, then the district has the ability to proceed with their disciplinary procedures as they would for any other student in the district, regardless of whether that student has a disability. They do not have any additional protections on top of that, other than the school district has an ongoing responsibility to provide that student with a free, appropriate public education. So the change in placement must still offer free, appropriate public education. However, they now have that ability outside the IEP process to move forward with pursuing that change in placement. There are ways to push back and contest that, which we will talk about also in a little bit. So, but if the answer is yes to either of those questions, yes, the conduct in question had a direct or substantial relationship to the child's disability, or the conduct in question was a direct result of the failure to implement the IEP, then the district cannot proceed with the disciplinary exclusion. They have to return the child to their placement that's in their IEP and conduct a functional behavior assessment and or revise the positive behavior support plan that's in place for the student. The only exception to that will be if the 45-day exception applies. So again, if it's not a manifestation of the disability, both those questions were answered no, then the district can move forward with their disciplinary exclusion or the expulsion, just as they would for all other students. Parents have the opportunity to disagree and to initiate due process proceedings. But as we said, there is still a FAPE requirement for students with disabilities who, even if it's found not to be a manifestation of their disability. When it is a manifestation, answer to the manifestation determination is yes. And because the conduct has direct and substantial relationship to the student's disability, the IEP team must either conduct a functional behavior assessment, unless the local education agency has already conducted an FBA before that before the behavior that results in the change of placement and related to the behavior of concern, and implement a behavioral intervention plan. Sometimes I use the acronym right here. Sometimes you'll see a behavior intervention plan, BIP, or positive behavior support plan, PBSP. I think PBSP is favored by Pennsylvania now. That's kind of the updated version in the regs, but I might use both interchangeably. You might hear both interchangeably. And so if the other option, if the conduct has direct and substantial relationship to disability, is if a behavior intervention plan is already in place, the team should review the behavior intervention plan and modify as necessary. So, and if the conduct is a result of the failure to implement the IEP, the local education agency has to take immediate steps to remedy those deficits, either in the implementation or in the design of the IEP. And that means meeting with each teacher and service provider to review their specific responsibilities related to implementing the child's IEP or behavior intervention plan, verifying that specific accommodations, modifications, and supports are in place, and determining whether any compensatory services might be necessary to address their failure to implement the student's IEP. And so I've mentioned this a few times. There is a 45-day exception for when a student with a disability is being subject to disciplinary exclusion, even if the conduct is a manifestation of their disability. So even if the conduct that they're being disciplined for is found to be a manifestation of their disability or a result of the team's failure to implement their IEP, they can still be unilaterally placed in an interim alternative education setting for up to 45 days if one of 4 scenarios occurs. If the student if the conduct involves carrying a dangerous weapon, knowingly using or possessing illegal drugs, or buying and selling a controlled substance, causing serious bodily danger, or presenting a danger to self or others as determined by a hearing officer. Now, these are specifically written in or determined in the IDEA what constitutes a dangerous weapon, what constitutes serious bodily injury. So, a pencil wouldn't constitute a dangerous weapon, even if the student used the pencil in a way that could be arguably weapon-like. A dangerous weapon is a device, instrument, material, or substance, animate or inanimate, that is used for or readily capable of causing death or serious bodily injury. And this excludes any knives of less than 2.5 inches in length. So a dangerous weapon really has to be a dangerous weapon that can cause death or serious bodily injury. An illegal drug is a controlled substance, but it does not include a substance that's legally possessed or used under the supervision of a licensed healthcare professional, or that is legally possessed or used under the Controlled Substances Act. And serious bodily injury is injury that would yield a substantial risk of death for the party who was injured, extreme physical pain, protracted and obvious disfigurement, or protracted loss or impairment of the function of a bodily member, organ, or mental faculty. So if a student throws something and it bruises somebody on the arm, that wouldn't amount to serious bodily injury. That is bodily injury, that's harm, but it is not serious bodily injury that would automatically warrant the school unilaterally placing that child into an interim alternative education setting for 45 days. However, a hearing officer can order a student be placed in a 45-day setting, even if those 3 circumstances aren't met, pursuant to an expedited hearing, if they've considered the following factors and determined that the student is a danger to himself or others. And this will usually be initiated by the school district. So if the school district wants to make that 45-day unilateral removal, but there's not those 3 circumstances of dangerous weapon, illegal drug, or serious bodily injury, they can petition for an expedited hearing with the Office of Dispute Resolution, saying that the student should be removed for 45 days because they're a danger to himself or others. The hearing officer would have to consider whether the district has demonstrated substantial evidence that maintaining current placement would likely result in injury to students or others. So you have to consider the appropriateness of the current educational placement, the reasonable efforts of the school district to minimize the risk of harm in current placement, and whether that student can be provided FAPE in their interim alternative education setting. So at the end of those 45 days, the student must return to his or her previous education setting, unless that school seeks another expedited hearing to keep that student in the IAES setting because he or she is an immediate danger to himself or others. But in lieu of the school filing to compel the state to keep your student in that 45-day placement, the student should be going back into their regular placement at the end of those 45 school days, unless the parent consents to a change in placement. And as I'm sure you're aware, there are stay put provisions in the IDEA, which means that if there is a conflict or dispute over a student's placement, they should stay put in their last agreed upon placement while that dispute is being resolved. if there is a challenge to an IAES placement, the student will remain in that alternative setting pending the decision of the hearing officer or until those 45 days expire. Something else important to keep in mind, particularly when we're talking about, dangerous weapons, illegal drugs, a school may refer or make a police report for certain incidents, and they do have the right to do that. They can report incidents to the police. However, if they are making a report to the police, they must ensure that the law enforcement agency is aware of the student's special education needs and has records of their IEP and disciplinary records, so that the appropriate authorities can consider the disability and IEP as part of their decision-making process. Additionally, if a criminal report is made, that is another circumstance where the school district must develop or modify the positive behavior support plan based on an appropriate functional behavior assessment. So if you disagree with a school's determination with a disciplinary exclusion, the relief that you can seek is through the Office of Dispute Resolution. Typically, we're going to be looking at expedited due process hearings as the major form of relief. However, there are other there's mediation available through Office of Dispute Resolution and other mechanisms that you may be able to utilize to try to reach an agreement with the school to work out the dispute. However, the main enforcement mechanism available to a parent or educational decision maker is filing for a due process hearing and a independent fact finder's determination on whether the disciplinary exclusion violates the student's rights as a student with a disability. So, and when you're filing based on a disciplinary exclusion, you get to have an expedited due process hearing. Typically, if you're filing a complaint about a student's educational program, about a school district's educational decision-making, there is a longer timeline. That there's a 30-day mandatory resolution period, and then there's another 45 days before the decision is required to be issued. But if we're talking about disciplinary exclusions, it's operating on an expedited timeline. A resolution meeting has to be held within 7 days. The due process hearing has to be held within 15 days. But as we discussed, the student will remain in an interim alternative education setting pending the decision, if the district had pursued that 45-day placement, and that's what you're challenging. So some of the things that you might challenge in a disciplinary exclusion in due process could be the results of a manifestation determination, saying that the school team maybe as the parent, the school team said it wasn't a manifestation, you said you think it was, and you want an independent fact finder to determine whether or not the conduct was a manifestation. It could be whether a student should be thought to be eligible for protections. Could be whether the IAES placement is appropriate. And it could also be whether a series of disciplinary measures constitutes a pattern of removals. So let's say, if the school is saying, no, when we call you to pick him up a few hours early, or when we're putting him in the counselor's office, that's not a pattern of removal. That shouldn't count as a suspension day. The way you can challenge that is by filing an expedited due process complaint and saying, this student has been subjected to exclusion on these dates in such and such a way, which should be considered a pattern of removal, and ultimately results is a change in placement. And expedited due process hearing can be requested by either party, either the school district or by the educational decision maker. So one question, this is kind of interesting, is when a school provides options to a student with a disability, well, an intellectual disability in particular, saying that they have options for what they can do, and the student says no, so they are given, they're supposed to hang out in a different space that's not what is required as part of their IEP. And the school's position is that the student is making that choice and it's not the school, so that's not an exclusion. That's not how it works. The student is a child with a disability, and if they are avoidant for their educational programming that the IEP team together determined was appropriate, then the IEP team needs to come together and determine why is this student avoiding where he's supposed to be? How can we support him or her to access their program? These students saying, I don't want to go to math isn't continually, and that being okay isn't appropriate. So if a student with an IEP refuses a current an out-of-district placement during the school year, and the district refuses to provide alternative placement, what are the options available for the family? I'm not quite sure I completely understand, but I'll try to explain to the best of my understanding. So if a school district is placing the student in an IAES placement and the family disagrees with it, then the relief available would be seeking due process, and filing that expedited due process hearing to have an independent fact finder determine, and that student would stay in that alternative placement while that decision is pending. If we're talking about just generally as part of the IEP process, the family feels that the student needs a different placement in order to make progress. We're not talking about discipline. We're just talking about generally as part of the student's IEP, their current placement is not appropriate, and we think that they should be in a different placement, and the school district's refusing that. That's a different question than disciplinary exclusion. That is looking at the appropriateness of the IEP and the program and placement that is outlined in that IEP, which could be enforced through a regular due process complaint. So how is a determination made whether a behavior is a manifestation of the disability? That is done through that manifestation determination meeting. The relevant personnel comes together, discusses the behavior, discusses the child's individual needs, what's in their IEP, what's in their evaluation reports, and discusses, is this related to their disability, or is, when this behavior happened, was it because the IEP wasn't being implemented? For example, if a student is supposed to have a one-to-one behavioral aid or paraprofessional with them throughout the entire school day, and the aide is not with them, and they throw something across the room, throw a chair, then that is arguably based a manifestation of that student's disability that's predicted within their behavior support plan, and as a result, the behavior happened as a result of the school not implementing the IEP with fidelity because the aide wasn't where the student was supposed to have an aide and the aide wasn't there. And a parent can disagree with the manifestation determination. The parent is a super important IEP team member, but ultimately the outcome of the manifestation determination is going to be issued by the school. The parent can advocate during the meeting, their input should be considered. However, there shouldn't be a predetermination going in that it's a manifestation that's being presented by the school. But if the school district says, we hear you, but we're still saying this wasn't a manifestation of their disability, then the relief that's available is filing that expedited due process hearing and asking an independent fact finder to weigh in on whether or not the behavior was a manifestation. So the next question is a school district legally permitted to dismiss a child with a disability 30 minutes early each day for the sake of getting specialized transportation out of the way before regular education students are dismissed? If that is a decision the IEP team came to together, that is permissible. If that is what the student needs in order to appropriately transition out of school, is that 30 minutes extra time before the other students dismissed, that is could be permissible. If it is a unilateral decision from an administrator or teacher saying, we don't want to deal with this, so you can go out to transportation early, then yes, that could be considered a pattern of exclusion. That is impermissible because it's not part of the IEP process. This question, I wish I had a better answer for. The question is, why does the school deny one-on-one support when recommendations have been submitted from medical and health professionals for such support as necessary for the student to remain in class? The staffing is a huge issue. And a lot of the times, and that shouldn't be driving what's in the IEP. The IEP services are based on what the student needs to make meaningful progress. It's not based on what resources are currently available to the school. However, a school district or administration may claim that in one-to-one support or an aid is not necessary for the student to make meaningful progress, and they are not required to provide it. And then it is the burden of proof is on the family to say, yes, they do require one-to-one support to make meaningful progress. And the evidence in support of that would be the recommendations from the medical and health professionals. The other argument that the school district may make is that there is a responsibility to educate students in their least restrictive environment. And they may claim it's overly restrictive to have a one-to-one support or one-to-one aid all day. And so it's not providing their least restrictive environment if they're including that in the IEP. Ultimately, that is a question of the appropriateness of the IEP, which is something that can be resolved either through mediation or through a due process complaint. And it's correct. The 2022 federal guidance, the schools do not need to wait for 10 days of aggregate suspension or 15 days of cumulative suspension to conduct a manifestation hearing to determine if the student's behavior was a result of their disability. It can occur at any time. There's no limit. It doesn't say you can only do the manifestation determination after 15 days of cumulative exclusion. As we discussed earlier, if there is a pattern of exclusion developing, a manifestation determination meeting can be held, and the parent and family can request one. There's nothing that prohibits the school from doing that. And if the school district is being uncooperative with calling it a manifestation determination meeting, say fine, let's call it let's have an IEP meeting. Ultimately, we're doing the same thing. We're talking about the current issues in place that are ongoing and how we need to modify the student's plan to prevent these interfering behaviors from moving forward. This is a good question. Is elopement considered self-harm or bodily injury? There are circumstances where elopement may be considered danger to the student's self or others. That's certainly the case. However, generally, elopement would not be considered is probably not violating anything in the code of conduct that would be subject to discipline. It would, but it could be the failure to adequately respond and address elopement may be a denial of faith and may result into an informal exclusion. Okay, and let's talk about the functional behavior assessment real quick. As we said, this is required if a student is an FBA is mandatory when an IEP team determines the student's behavior is interfering with their learning or the learning of others, and the team requires additional information to provide appropriate educational programming. The team must conduct an FBA if the conduct subject to disciplinary exclusion is determined to be a manifestation of a student's disability, and there is not a relevant functional behavior assessment that's been conducted on that behavior of concern. If a referral is made to law enforcement, or if a 45-day removal proceeding is initiated, a functional behavior assessment must be conducted. It may be appropriate to conduct a functional behavior assessment, even if the IEP team determines the child's conduct is not a manifestation of their disability. Perhaps it's maybe that's not established yet, but let's look into if that is a behavior that's been repeating, if that's needs to be analyzed. Perhaps a FBA would be appropriate. And that's incorrect, because if it's an IAES, they have to provide a functional behavior assessment or modify the behavior support plan. And going back, sorry, a little out of order, a functional behavior assessment is an evaluated process for addressing problematic behavior. It relies on a variety of measures to identify the purposes or the function of specific behaviors and to aid the IEP team in developing interventions to directly address the problem behavior. So generally, there are 4 steps of a functional behavior assessment, and functional behavior assessments should be conducted by trained personnel. Doesn't necessarily have to be a certified BCBA, but it should be somebody who has significant training in conducting a functional behavior assessment. So I'm sure we've all seen functional behavior assessments that kind of look like check the box, fill it in, doesn't really apply to the student or specifically identify what the behaviors of concern are or what's going on. So, this can be something that may need to be more of a collaborative process and might require more push if the functional behavior assessment that's initially done isn't really revealing anything informative. So the first step of that functional behavior assessment is identifying the behavior that is causing learning or discipline problems. And typically, from what my understanding is, a functional behavior assessment should not focus on more than 3 behaviors at a time. And a positive behavior support plan really shouldn't focus on more than 3 target behaviors at a time. You're looking at the most interfering or concerning behaviors, because then you can once those are supported and addressed, you can look at others. But usually you're just looking at the 3 main concerning behaviors. So you want to define that behavior in very specific terms that are easy to communicate and simple to measure and record. The individual conducting the assessment should be observing the student's behavior in a variety of different settings and during different types of activities, and should be collecting data on their observations of that student's behavior. That the assessor should also be conducting interviews with school staff and with educational decision makers in order to pinpoint the particular patterns of that behavior. So that's this kind of repetitious, but really, it's very important that that functional behavior assessment has data collection, direct observation, and is very specific to what's going on with that student. And after that functional behavior assessment is conducted, there should be a hypothesis about the causes of the behavior and what function that behavior is serving for the student. Is it a method of avoidance? Is it a method of attention? How is that serving them? And Then you look at developing that behavior intervention plan or the positive behavior support plan, and that is based on that FBA. So the behavior intervention plan is a plan that's designed to teach and reward positive behaviors and prevent or eliminate problem behaviors. And though that behavior intervention plan should specify the inappropriate behaviors, the function of those behaviors, strategies to prevent the behaviors, replacement skills that should be taught, and how those implementing the plan should react to the inappropriate behaviors. So typically what you will see is it'll be in ABC format. So it will, we'll see what the behavior is. And then there'll be a list of the antecedents. What is happening before the behavior surfaces? What are some strategies you can implement before as antecedents to prevent the behavior from occurring? What is that behavior? We're specifically defining it. And then C, looking at the consequences. The positive consequences that can result to support positive behavior, and the negative consequences that can be applied when the behavior when that behavior occurs. And they should be very specifically defined. Sometimes I'll see in positive behavior support plans that there is actually no positive behavior support. It's just saying, well, when the student does this, here's what the team should do. But we should also be looking at what replacement strategies are we trying to help the student engage in to prevent them from engaging in that behavior. And when they do engage in those replacement strategies, how are we providing positive reinforcement for that? For example, going back to our example about a student who's throwing things when they get frustrated, perhaps the replacement behavior is asking for a break. It's saying they're frustrated. And then how is the team reinforcing that positively when the student is engaging in that positive behavior instead of the behavior you're trying to eliminate? So throughout the positive behavior support plan process and the implementation, there should be data collection. This is hard and certainly hard to find quantifiable data that's actually been collected. But if there are ongoing behavioral concerns that are as part of the behavior support plan, the first question I have is, okay, where's your data? Where's the data on the implementation of this positive behavior support plan and how it has and how it's effective or ineffective at this time? Usually there's no data. And sometimes it's, we're not really implementing what's on this page. We're trying different strategies as they come. Or like some teachers have good strategies that work for students. Some are trying different strategies that aren't working. So it's important that all what's working and what's not working is being considered and collected, and so that the behavior plan is continuing to be modified and revised so that it is the most useful and the most appropriate for the whole team to be implementing with fidelity. So the key takeaways you take from what we've talked about today is that the LEAs have responsibility to review and revise a child's IEP to ensure that they're getting appropriate behavioral supports and services to address behavior that's resulting in disciplinary removals. And school must take the steps necessary to ensure that a child's IEP includes positive behavior intervention, supports, and other strategies which are being consistently implemented. And the student's placement, a student with a disabilities placement should not be changed formally or informally outside of the IEP process. Okay, I can look back through some more questions, or if there's any other questions you'd like to add.
Great. Thank you so much, Jennifer. This was really, really enlightening. We touched on a lot of topics. We definitely have questions still coming in through the chat and the Q&A. And we'll get to those, as well as anyone who has any questions they want to ask verbally. We're going to go ahead and open that up. So at this point, I'm going to end the recording. Thank you again, Jennifer.